I gotta remember to do that. Not just do that live for everyone to see. But hey, welcome to the No State Project live from the fortified compound in Mesa, Arizona. Glad to be with you here today. It is episode 128 of the big show. And got a lot of stuff to get to. We will be taking calls. I will give that out several times during the show. I probably should have opened that up already. Uh, I am going to be taking calls, and I am on the call line. Didn't open up the actual software, but I'm doing that now. And so what we're going to do is we'll give that number out. And it's 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. If you want to join me on the big show. If you are being attacked by a bureaucrat, want to learn how to more effectively defend yourself, or if you disagree with something that I have presented on the show, I have my facts wrong, my logic is crap, then definitely join me on the big show. It's 218-632-9399. Passcode is 2020 with the pound sign. And I'd love to be able to hash that out with you. If it's just criticism as far as my looks, or it's just trolling, that won't work. But if you have an honest criticism where you're actually able to quote back my argument or my facts instead of what do you call that? That their straw man. If you can actually address the argument or the material that you disagree with, then great, we can have a great conversation. Because dissent, regardless of what a few people may say, is welcome here on the broadcast. And yeah, I do have a mute button, but I am doing a show, and I got to keep control of it. So if somebody is talking over me, or they're interrupting, or they're just not answering the question, addressing the actual issue, then you gotta keep the show on track. Okay, but it takes a lot for me to do that. If anybody who is familiar with the big show, and if you want to be able to help support the show, your continued support is appreciated. I appreciate everyone able to do that. If you'd like to, it's markstevens.sells.com. That's SELZ, markstevens.sells.com, and you could just go to markstevens.net. Also, especially if you are looking to effectively defend yourself, I don't expect you to take anything that I say on faith. There's evidence. There is direct evidence on the website where people have replicated the success, whether it's the United States, Canada, Australia, or even England. We have documented success on 4 continents. Of course, EL has had, in Israel, No State Project Israel has had success in the Israeli courts. And it's really tough to get anything through there. We talk about some are, they're all corrupt, but boy, you've got your hands full in Israel. I give anybody, an attaboy if they're an activist in Israel and trying to go against the courts in Israel, because that you're really taking on something there. Getting a line of calls here. So I am going to get to the callers, but I do need to address some and get to some of the information and why I tentatively called the show. What's a citizen? Is there supporting evidence? Because this is something that came up in the last broadcast, and while it may just be trolling, someone made the claim that, because when I broke down using Loria versus United States, and I will get the full citation in just a moment, so just bear with me, that I'm somehow not understanding. This is that I don't understand what dicta is, and this is a very, very, very long, well-worn complaint against me that's usually made by a couple of lawyers. And that they won't go so far as to say that the dicta, which I don't even know if it really qualifies as dicta, because we're going to get to that. Because the dicta can't have anything really to do with the decision, and the decision in Loria had to do with citizenship. So what they don't do is to go so far as to say that the definition that I use of a citizen, which is not exclusive to Loria versus United States, but that's just the one that it's easy to remember. It's very clear cut. It's just the one that I use. It's not the only one, but they won't. They want to criticize my use of that and how I use what that definition to show that there is no citizen, there is no body politic, and there is no state, no government. It's literally just men, a gang of men and women forcing us to pay them, which is why we're anarchists. They want to. So instead of addressing the facts that they're just men and women forcing us to give the money, they want to try to split hairs and say that the definition I'm using is just dicta. So a question that I've put to these lawyers is the definition wrong? Is the Supreme Court completely off base when they define citizen in that case? Another thing was that only naturalized citizens, this was just, oh my gosh, this has got to be trolling. It was put there that, and I should have got a screen cap of this, that only naturalized citizens are comprehended in that definition, which, again, I'll read it in just a second. Not only that, but they went so far as to say that the duty of allegiance is something that's only owing by naturalized citizens, because they're the ones who take an oath. And someone like me, who's born in, who's born in Cheektowaga, there in Western New York, since so-called natural-born citizens don't take the oath, that the allegiance doesn't apply to them. And so what I brought out on the show last week, it was just, it just, some people just disagree to disagree and stir things up. There's no logic behind it whatsoever. So one of the things that I brought up, and it's something that's going on in the media, in the news right now about Ukraine and Captain Cheeto or Bone Spur. Cheeto Bone Spur should be is that about treason? And so if you look at the actual statute and the Constitution for treason, it says whoever owing allegiance to the United States levies war against them or adheres to their enemies. I'm not going to read the whole thing; it's not necessary. But whoever owing allegiance, so this critic who just has to just disagree with me, it seems, just for the sake of disagreeing, that only naturalized citizens can actually be charged with treason. That a natural-born citizen, according to the critic, has no duty of allegiance because they don't swear the oath. They can't be charged with treason. It's just, oh my gosh! And I'm the narcissist. Oh, so let's get into this. So Laurie versus United States is the case opinion that I use because it has a very straightforward, easy to understand, fairly unambiguous definition of what a citizen is that coincides or is consistent with hundreds of years worth of court decisions in the United States and England, where it all came from. So it's consistent with that. And if you're interested in seeing somebody desperately trying to knock down my argument and show that this is not applicable, go to my forum and go way back. And so I'm discussing this with a couple lawyers. And they insist it's just dicta, but they won't say whether it's right or wrong. Well, you have to use a definition in the law. It is in a Supreme Court decision. In fact, after I go through Laurie versus United States, I will go back to the another Supreme Court case, as well as the Massachusetts Constitution, which spells it out fairly clear also. And so unless you're going to say that the Constitution, which is supposed to be supreme law of the land, as far as the Commonwealth of Massachusetts, then it's not dicta. It's supposed to be the supreme law. The Constitution is a law. It's not a mere statute. It's organic, superior, supreme law. It's not a court opinion like this is. But remember, this is pretty damn consistent. So I'm not just going to a let's say a secondary source, it would be called in law, where you look at what a citizen or citizenship is. So here it says the privilege of membership in a political society implying a duty of allegiance on the part of the member and a duty of protection on the part of the society. The status of a citizen with its respective rights and duties. Now that's Ballantyne's Law Dictionary, and it's what do we got there? It's the third edition Ballantine. So you find that actually on page 202 there. But Laurie versus United States is what I use, of course, to knock down this argument that there are citizens. And we discussed this on the last show where because a citizen is a member of the body politic owing a duty of allegiance in return for a duty of protection, that you have to show that those duties of allegiance and protection are real, that you can prove, at least by a preponderance of the evidence, that those obligations were created and exist. And the facts are, in my position, has always been that because they are just men and women, those called government, because they're just men and women forcing us to give them money, that those duties of allegiance and protection were never created and could not be created under the pay or go to prison facts. That proposition. So it's 231 U.S. page 9. Now, this goes back to 1913. Now, I'm fairly sure we're going to have some patriot types whose heads are going to explode and say, but you can't cite any cases before 1935 because of the bankruptcy. Please. What's important here, too, is the Supreme Court. Well, let's first read what dicta is. Dicta is the plural form of dictum, a statement of opinion or belief considered authoritative because of the dignity of the person making it. Here, it's a majority of the United States Supreme Court. And this case, as far as I know, and I've shepherdized a lot of cases, has never been overturned or modified as far as this part. The term is generally used to describe a court's discussion of points or questions not raised by the record or its suggestion of rules not applicable in the case at bar. Judicial dictum is an opinion by a court on a question that is not essential to its decision, even though it may be directly involved. Okay, this here, it is directly involved, and it is something that they're using to base their decision on. Now, if it's dictum, that does not mean that that what they're saying is automatically wrong. It's helping the court make a decision. And judges, when they're making an honest decision or think that they're making an honest decision, will go way out of their way to give all their reasoning. I read a case the other day, a dissenting opinion that went on for something like 8 pages on one issue of proximate cause. They will explain why they are ruling the way they're ruling, which you don't see in tax cases. Under the Constitution of the United States, a naturalized citizen stands on equal footing with the native citizen in all respects, save that of eligibility to the presidency. So what applies to the natural-born citizen applies to the naturalized citizen, and vice versa. Whatever applies to the naturalized citizen applies to the natural-born citizen. Again, we're just talking theory here. We're not talking about anything that's real. So then we get down, we get to the part just above that. I went the wrong way. This is the part that I'm always quoting, and someone is trying to, and a few lawyers and their associates are trying to discredit the whole thing because this is not a holding of the court. It's just what the court discussed regarding how it was going to rule and why it was going to rule a certain way. Citizenship is membership in a political society. It implies the reciprocal obligations as compensation for each other of a duty of allegiance on the part of the member and a duty of protection on the part of the society. Now, this is a really, really old concept. It predates 1913 by practically a millennium. This is not new. So if somebody wants to turn around and say that the Supreme Court got this wrong, then step up. Because if it's something that we're going to discuss on the show, and I know in advance, I can get a laundry list of spanning several hundred years that is actually accurate. I mean, look at the treason, owing allegiance. So if we go to the Massachusetts Constitution, again, this is not dicta. This is not opinion of a court. This is not even the holding of a court. In the Massachusetts preamble to the Constitution, yeah, I know. Well, the preamble doesn't count. I can hear that crap now. But this is part of the Constitution, the supreme law. The body politic is formed by a voluntary association of individuals. It is a social compact. by which the whole people covenants with each citizen, and each citizen with the whole people, that all shall be governed by certain laws for the common good. It is the duty of the people, therefore, in framing the constitution of government, to provide an equitable mode of making law. Okay, that's not important. But what's important is that they're saying it's a covenant. It's a social compact, which gets back to the language here. Citizenship is membership in a political society and implies the reciprocal obligations as compensation for each other of a duty of allegiance on the part of the member and a duty of protection on the part of the society. That's why you get into court cases about failing to protect, where I talk about DeShaney versus County of Winnebago, where they talk about there are thousands of cases that talk about this. They talk about the government's duty to protect the people, and they talk about it's the duty is to protect the people at large in return for their duty of allegiance. So we go to the Yik Wu case. I think that's what it was. I don't want to scroll up and lose my place because this is a really long case. But if we look at other court cases, this is United States versus Won Kim Ark. There are a lot of Chinese cases because, hey, United States government has always been blatantly racist. And that's 16 U.S. page 649 was where that case starts. And what they're doing here is they are quoting from a Justice Johnson, and I know dicta. This is 3 Peters Reports, page 120, and they are citing allegiance is nothing more than the tie or duty of obedience of a subject to the sovereign under whose protection he is. And allegiance by birth is that which arises from being born within the dominions and under the protection of a particular sovereign. 2 things usually occur to create citizenship. First, birth locally within the dominions of the sovereign, and secondly, birth within the protection and obedience, or in other words, within the allegiance of the sovereign. That is, the party must be born within a place where the sovereign is at the time in full possession and exercise of his power, and the party must also at its birth derive protection from, and consequently owe obedience or allegiance to the sovereign as such de facto. There are some exceptions which are founded upon peculiar reasons and which indeed illustrate and confirm the general doctrine. Thus, a person who is born on the ocean is a subject of the prince to whom his parents then owe allegiance, for he is still deemed under the protection of the sovereign. So what they do is they go through and they explain in here, there's a Latin phrase. Again, this Latin phrase is hundreds of years old, of which the United States system was apparently based on. It's a Latin phrase meaning protection draws to itself allegiance, and allegiance protection. It's in this particular case. So protectio trahit subjectum et subjectio protectionum. So it's kind of like a Harry Potter thing. You could just say you're entitled to protection, and magically you owe allegiance. So this is really, really old, well-worn stuff. It's not up for dispute used typically, except in these, on my forum or on my YouTube channel, where somebody wants to try to destroy the argument, which they fail completely. Someone just tell me, if you disagree with my position, is this yes or no? If I don't even know if I'm not even watching because I'm too busy doing the show. But if there's somebody listening who disagrees and thinks that the Supreme Court in United States versus Oloria versus United States, if you think that that is wrong and that definition is totally off base, that citizenship has nothing to do with allegiance and protection, please, 218-632-9399. The passcode is 2020 with the pound sign. Set me right. Show me where the Supreme Court of the United States is wrong in their definition of what a citizen is. Because it seems to be pretty straightforward. But when you're saying things and you're making criticisms just to be contrary, yeah. But to think that only naturalized citizens, which neither one exists, but just for sake of argument, everybody, but to think that only naturalized citizens have a duty of allegiance because they swear an oath and not a natural born is just ridiculous. I guess I'm not using legal logic and I'm trying to be consistent here. So apparently, according to this critic, only naturalized citizens can commit treason. Natural born citizens don't owe allegiance, have no duty of protection owed to them, and they can do what looks like treason but isn't treason because there's no duty of allegiance owed. Okay. Yeah. So I hope that is put to rest. I do want to real quick for those who may just be new and tuning in. I don't use this information. I don't need to use this information in court. It is not forming the basis of a legal defense. Okay. It's knowing that information, knowing that there's no evidence and couldn't be any evidence to support the government's claim, a prosecutor's claim, that the laws apply and you violate it just because you're physically in Arizona. That's how you know that claim has no merit. There's no reason to go into court and start talking about it unless they bring it up. I mean, I've had a public defender in Alaska stare me down saying, well, you're a citizen of the United States. I said, really? Really? And do you have any evidence to prove that that's actually true? Can you prove that there's a duty of allegiance in return for a duty of protection created? Do you have any factual knowledge of that? Personal knowledge? Well, he swore at me and walked away. If you're going to accuse somebody and make a legal allegation that they're a citizen, you got to have the proof. But generally, we don't have to bring that stuff up. It's usually not an issue. Tax cases, maybe. Traffic, drugs, no. No, it's not. Typically not a reason. But it's why we can confidently go in and we can challenge their position. Their position is that that because I'm physically in Arizona, their laws apply and create obligations and give them jurisdiction over me. No evidence to prove that that's true. So remember, my position is that their claim doesn't have evidence. So if you're going to come and they're going to counter that, if they turn around and say, well, you're this, that, and the other thing, and you're arguing that the laws don't apply, that's not the argument. No, my position is your claim, your foundational legal claim that you made and you affirmed. There's no evidence or insufficient evidence to support it. Now, if you want to address that and think that you do have the evidence, I'm all ears. Not really. I think it's more I'm all nose. So anyway, if there's any questions or concerns about that, you can call into the broadcast. I'll put the headphones on. And especially if you dissent, if I will have the links. I know I got to get 4 shows posted now. I will have the links of what I was reading from. So I will cite, all the citations will be over there. But for Laurie versus the United States, that seems to be one that, like at least once a week, somebody's saying, dude, what is that case you keep citing? I will put that link right now into the chat. Is it dicta? Yeah, very well might be. I will be the first to admit it is absolutely not a holding of that particular court, but the court used it as a basis for their ultimate holdings. So if you are saying that I'm wrong, that that's not what a citizen is, then what you're saying is that the Supreme Court got it wrong. And I'd love to see somebody have counter. Remember, that is a primary source. Secondary sources don't count. So you can go into, a law dictionary. It doesn't matter what the dictionary definition of a citizen is. That's not a primary source. I think the lawyers would be the first ones. Oh yeah, he's gonna. Yeah. The dictionary is not going to hold any water over the court. So yeah. Okay. So let us get to the calls here without further ado. Make sure we are not muted up there. Oh, we've got. Oh, I hope we got some good news there, Matthew. Welcome back from Alberta.
Hi, yeah, Matthew here.
What do you got for us today?
Testing.
Can you not hear me?
I can hear you, yes.
All right, great. What do you got for us today, Matthew?
Well, basically, I've been doing a lot of homework for the past week. I kind of do quite a bit of homework for the last few years, but since this incident, I kind of just came down to a couple questions that I can't really find out for myself. So I kind of wanted to phone in and maybe get your opinion on some of these questions.
Okay.
Okay, I guess I'll dive right into it here. In what way are you most familiar mailing forms or applications, or more so, which of these forms or applications would help move towards a motion to dismiss or to at least address my point?
It's a little confusing, the question.
Sorry.
What motions or forms would I file to have my motion to
Well,
a motion to dismiss addressed?
yeah, like I'm just kind of figuring I can mail some documents or some information so before I go to court, I'm a little bit more prepared. Like I just kind of was looking over lots of Alberta's forms, and I kind of was thinking that these four that I kind of researched were specific to making a motion to dismiss at all, because I couldn't really find a form at all that said the words on the top. So I found a application that allows me to make a motion to dismiss.
Well, in Canada, it may actually be called an application to dismiss instead of a motion to dismiss, like in England. That's not always been reported to me that you had to do that. You did mail a copy to the clerk of the court, right?
I just been doing quite a bit of research before I did it, because I don't necessarily know if I should, because I don't want to get myself into trouble not even knowing which form I even sent in. So I got about 4 weeks before I have to attend. So I'm going to use tonight and then tomorrow to do my filing if I even need to do any mailing. So
Weren't you actually being charged in an Idaho court, or am I mixing you up with somebody else?
no, I haven't left the country.
Okay, that's somebody else. All right. Well, if you haven't mailed it in yet, I don't like to do it with such a because it's not just the motion or application to dismiss that needs to be filed with the clerk and a copy sent to the prosecution. It is the discovery request, and if there's going to be a pretrial issue where the prosecution is not giving the exculpatory information, which is information that shows that you're innocent, that you can show that tends to impeach the prosecution's case or witness, I want to know that a little bit more in advance so that I can address that and not have to address it the day of trial. Because now you might be stuck having to argue, let's say, a motion for in limine or a motion for to dismiss for prosecutorial misconduct, or just argue a discovery violation and do that at the day of trial.
Okay, I did find something that refers to a discovery. They over here in Alberta call it a search request. So I'm just kind of was reading that one, and I kind of figured that would have been because it did have a bunch of options about what I was asking or what I was demanding the judge to do, and stuff like that. I could look it up on my computer right now, but don't want to get too distracted. So, yeah, I did find a search request form, so I was going to fill that out as accurate as possible. So that's one of the things you are pretty familiar with, having to mail to the court that I would need to show up to.
Well, you have a trial set in 4 weeks or so. So yeah, I would get the discovery. I have a discovery request that covers the exculpatory information. It works pretty good for these misdemeanor cases. So the information is there. You might find the same information. You probably will find a lot of the same information on one of their forms. I kind of doubt that, but you may get that on there. I would get that file. I personally like to file it as soon as I can, so that I know a little more in advance all right, and I can give the judge an opportunity to make, to see that, hey, I am going to be arguing that this prosecutor is guilty of misconduct, that they're arguing without evidence. They're actually misleading. They're trying to mislead the court.
I did put myself off a little bit with this, and just doing so much research, I guess I just kind of lost track of time. But I definitely understand what you're saying about having a little bit more time to look into it after I get the information. I guess if would that application that I fill out for a motion to dismiss go with the request to search, or the search request?
I
Or
always
the discovery.
I filed a motion to dismiss with the discovery or disclosure request. I put them in together, and for those listening new, whatever you file with the clerk or the court, you have to send a copy, mail a copy to the plaintiff, the prosecution.
Okay, that makes sense. Yeah. I guess no other motions or forms that you would recommend to me that I should look into before I send anything in to both of those people?
That kind of gets the ball going. I mean, unless we know that there's an issue, let's say, for example, you may have to file a response or reply if they respond to the motion or application to dismiss. You may have to file something regarding how they respond to the discovery request. We don't know because you haven't, you don't have, we won't know until you set things in motion by filing the motion to dismiss and the discovery request.
Okay. I think I might have that one kind of written down. I think it might be called a statement of defense of, and that would be me. Or no, I guess that would be the defense I would have after all the information they gave me. So
if they're requiring you to do a statement of defense, my defense would be that the prosecutor is arguing without evidence and a qualified witness, that their foundational legal claims going to jurisdiction, personal and subject matter, are grossly insufficient, and that they know that they're insufficient and are prosecuting anyway. That would be my that would be my defense argument. My defense strategy.
Right. I definitely had that in mind for sure. I actually had that written down a little, but I guess a next part of that I couldn't figure out because I was researching the definition of a remedy sought, and I wasn't too sure exactly how to play that in my head with all the definitions I was looking at. I was wondering if you can help me define what a remedy sought is, if you have any idea what that means.
Well, the remedy sought is what you're having, what you want the judge to do. So in a motion to dismiss, the remedy that you are seeking, so the remedy sought is the dismissal of the prosecution's complaint for lack of evidence proving jurisdiction.
Okay. Yes, definitely. I can understand a little bit better now. I'll have to just do a little bit more research on that. Maybe I can use that to my advantage.
Well, that's just a matter of the form. It's a matter of the procedure. I mean, it's a standard thing, So lawyers in England, for example, it'll be a prayer. It'll be a prayer to the Lord. Here, this is just it's because you're asking the Lord Chancellor to do or not do something for you. This is just a more secular way of saying it, where the remedy sought. What do you want the court to do? Oh, I want him to dismiss because the foundational claim of the prosecution is groundless. Oh, okay. And then, of course, it's
right.
But that's that's a pretty simple issue.
Okay. Yeah, definitely. I couldn't wrap my head around how simple it could have been, So, I guess just my last one that I kind of wanted to mention was an order to appear application. So it kind of like makes me think that I'm making all the officers that were at the scene of the bust or whatever whatever they were doing. There was 3 of them, and I'm just wondering, would that be relevant at all? Just sending all three of those officers in order to appear to that court date on the 17th there?
Well, the prosecution has to give you a witness list on who they're planning on calling, and there's going to be at least one of those three that have to be there. And the prosecution, since it's a prosecution witness, it's up to the prosecutor to make sure that they're there. The only time I would, if I had a witness list, like in the situation like you're talking about, and I know that there were three officers there, and they're only calling one, the only reason why I may even be inclined to bring in the other two is if they have, depending on the circumstances, if they had contradictory statements that they, if they could, and that they could contradict what the main prosecution witness was saying. Other than that, I wouldn't even bother. And if the prosecution wasn't taking steps to have any of their witnesses, okay, great. He can't possibly make his case without a witness. So we just had one recently. I'm getting so far behind with shows and videos. Someone recently had where the prosecutor was stumbling over their words and eventually was able to get the judge to understand that the police officer would not be showing up that day. So.
Okay. Well, I had just one more question. I think it'd be pretty easy for you to kind of determine whether or not I should make these statements. But in your opinion, what's the most helpful statement to make when your name is called? And I have the two stuck in my head that I should say, "I am here concerning the matter. May I have your name, please?" And the other example that I have is, "I intend to plead guilty. Has the prosecutor presented any evidence that constitutional laws apply, or to the living, breathing human being that was in Alberta physically?"
Well, to the first one, no, I would not take an approach like that. And I hope you don't take an approach like that, because that is just going to throw up a huge red flag that you're some kind of sovereign. If anything, you could say, I'm here on, I'm here under threat, duress, and coercion to participate. For the second one, I would not get into trying to plead guilty unless there is extreme resistance to my motion or application to dismiss. So if the judge just denies it outright, will not allow any dialogue on it whatsoever, then and wants to move immediately to trial, then I would do that. So I would suggest watching the video again that I have about that, where I cover in a lot more detail about that. But the point is to be able to keep the focus on the prosecution's lack of evidence instead of having them fast track it to trial. Okay.
Okay. Definitely understandable. That's really helpful. Thank you, Mark. I guess I'll let you go. I'm going to keep doing my research, and I'm maybe keep in touch with you and let you know what's going on. So
yeah, maybe on another show, we don't have quite so many callers, because I got a huge line of calls, and I'm going to get to everybody. I promise. I'll do my best. We can do a little bit more role playing.
To the moon here.
We could do some role playing and help get you more prepared, because you need some work. You need some work. Okay.
Yeah, definitely. Public speaking, is probably one of the hardest things they say to do.
Well, for a lot of people it is. So I got to let you go, but good luck. If you have any other questions, call again or email.
All right. Thank you very much.
Appreciate it. All right. Wow. Everyone, got 20 minutes left, so we'll do our best to get to everybody. We got Sebastian in Los Angeles. Hey, I got the right shirt on for Sebastian.
Hey, Mark. I like that Harry Potter style you're using.
Oh.
Protectum ad nauseum resecution.
Yeah, I think you're
I wish I could just have them leave me alone.
Yeah, really. It's about damn time. But yeah, what he's referencing is protectio trahit subjectium et subjectio protectium.
Poof.
All of it. Yeah, now you got a citizen.
I got a letter from the Los Angeles Office of Finance for business tax, because I do some ride share, gig economy stuff. I'm also a musician. And so they're like, "Oh, the Franchise Tax Board told us you got a 1099 in 2016. So now you have to give us all this information and you must reply to this letter. I'm wondering, like, should I send a demur or just send a letter and ask them a bunch of questions pertaining to what's in the demur? What obligation do I have to reply, and what's their jurisdiction over me? All that.
Well, you don't want to use a demur here because that's for court. You're not in court. It doesn't sound like it's a court proceeding. So they just want information. So I guess I would, my first inclination, I mean, is there a name on there and a contact number?
There's a name, but it's not signed. So it seems like it's computer generated. And then the contact number, there's like an 844 number, and then you have to wait like a really long time to get in touch with anybody.
I guess in that because of that, I would send a letter back asking for a couple of questions and ask for a name and direct contact number so that you can contact them in an effort to, in a good faith effort to resolve this. So I guess I would ask, hey, are you guys operating on the presumption that just because I'm physically in California that your laws apply and give you jurisdiction to require this? And then ask for the contact information so that you can discuss it and possibly get this resolved without an escalation.
Okay, yeah, that'd be good. And then you know how like sometimes they say that, like I heard in your call of shame, they're like, well, you're a taxpayer because you did you already paid taxes with the franchise tax board. And then I could just say like, well, that's not evidence that I'm a taxpayer. I did it under threat, duress, and coercion.
The problem with that is I agree with what you're saying, but as far as effectively communicating in a manner so that you can get this thing tossed out, it doesn't cut it because you want to stick to asking a question. So a better way, the better thing to say would be, so is it your position that the compulsory 1099 or the compulsory return, that is somehow evidence proving your Constitution applies? Okay. See the difference?
Yeah.
If you just make a statement, he's going to disagree with you. And we're trying to get this resolved in good faith. We want it. We want a positive resolution. Both sides think they're doing the right thing. He thinks he's right. You think you're right. The better way to go about it, in my experience, is to just accept their position and find out why they think that's true. They think it's true because that's just the way they do things. They don't have any actual proof. And with the franchise tax board, because they, any government, because they can use threats of violence and get what they want. They're not afraid of you. They don't need to be, they've got all the guns, they've got all the prisons and all the businesses in California. They're deathly afraid of them. They don't give a damn about us. We're nothing to them. So just accept their position. Oh, because you're physically in California. Yeah, we have the laws apply and we have jurisdiction. Great. Let's see some proof.
And then if they say like, well, because you got money in Los Angeles, then it's like, well, that presupposes the constitutional argument in the first place, right?
Well, you just keep going. Okay, so you've changed your position. So your new position is that just because I received money, that somehow proves that your Constitution applies and gives you jurisdiction. You gotta, if they're going to change their position, then you just have to make sure that you understand it and you're quoting them right. You don't want to do like what critics do to me and what courts do to a lot of people, a lot of us, and misquote them. So your new position is just because I received money in California, that somehow proves your Constitution applies, giving you jurisdiction. And I was like, well, yeah. And then the way it goes for me, and I have calls of this on the website, is, oh, well, really? So, you ask them exactly how does my getting the money prove, which is, how does that prove your Constitution applies to me? And their go-to is, well, the Revenue and Taxation Code. So then you got to say, what I do is I say, oh, so your position is the Revenue and Taxation Code somehow is evidence proving the Constitution applies to me and creates obligations. They'll say yes. Then you ask the leading question that I ask that gets them to reverse that garbage is, I'm sorry, isn't that backwards? Isn't the Constitution the authority and the proof that the code applies, not the other way around? Oh yeah, yeah, you're right. The code is not proof the Constitution applies. Okay, now you're back at square one. Okay, so exactly how does my receiving money in California prove the Constitution applies to me? And usually, what they'll do is they'll say it's an assumption, which it is, or they won't want to talk to you anymore, or some other stupid thing. Those are the general response, the same two responses I typically get.
Okay, I'll try and give that a shot. I'll see if I can just write them a letter and see if I can talk to someone directly and get some some questions answered.
Yeah.
And then hopefully then they don't retaliate against me just for asking questions and trying to resolve it in good faith.
Well, we can only hope. I mean, as long, hey, at least it's not the franchise tax board, because I'll tell you and everybody else again. I have to say this every show: you do not have remedy against the franchise tax board. You either pay, or if you've got a garnishment, you got to quit. You got to go somewhere else. There is no defeating the franchise tax board in California. They're just too dishonest. But here, you got a good chance. So keep in touch. Let me know what they say.
Okay. All right. Thanks, Mark.
Appreciate the call. Sebastian in Los Angeles. And I hate that it is that way, but the franchise tax board and the Board of Tax Appeals and the courts have long proved they are not interested in the truth. They are not interested in justice and fairness and due process. They don't give a damn. I reported on the show what happened recently this summer or this spring. Somebody with the Board of Tax Appeals, I can't remember his name off the top of my head. He was an administrative law judge, one of a few, but he was handling the pre-hearing conference. And he said point blank, there's nothing that they can do if the franchise tax board is lying and misrepresenting the record. What they can do is sanction the defendant $5,000 for a frivolous argument, but they can't do anything against the franchise tax board, and they won't do anything. So if the franchise tax board is permitted to lie, you had no remedy. When they are that corrupt. So we're going to go to the East Coast now. He's been on the show. Everyone's been on the show so far today before. But you got Roy in Baltimore. Welcome back to the show.
Oh, hey, Mark. Well, I'm not in Baltimore no more. I moved to Virginia because I have a CDL now. But I have a red light ticket in Chambersburg, Pennsylvania, and I wanted to know, can I get a motion template from your website? Well, how do I fill it out for say the Brady request and a motion to dismiss with a lack of jurisdiction?
Oh, that's it. Most of it, I have instructions. So those who are interested in getting that, most of them are crossed over for whatever so-called state that you happen to be in. And I do provide instructions to help you fit, edit it appropriately. And when you file, particular documents that I send, because when you get the motion to dismiss, it also comes with a motion in limine. It comes with a discovery request, and it comes with a proposed plea of guilty. And in addition to that, depending on how things go, you can always call the show with questions. So if it or in an email first, but I also have a motion to dismiss for prosecutorial misconduct, but I send that only if it's needed. But if someone wants it, just email me, markstevens@mail.com, and I'm happy to send that template. And it does need to be edited for your facts to be in there. So just please keep that in mind. I don't want anyone ever calling me again saying, well, the judge wanted to know who Tiffany Castillo was, because she's a prosecutor in Massachusetts and not where this individual, they left the prosecutors. It's like they didn't do any editing. It's fairly minimal. Your job, your editing on the motion to dismiss and the Brady request, for example, is very minimal. It's your name, address, the name of the court it's in, the docket number, stuff like that.
Okay, because on a ticket, I had to send it back within 10 days. I put under TDC, under threat, duress, and coercion. I put my signature on it. Basically, when I got stopped by the cop, he asked me a question. He asked, well, are you getting off of work? And I told him I don't answer questions, and he got upset about that. So it was a ticket out of retaliation because I wouldn't answer any questions. So I mean,
What
that's,
questions did he ask
I
you?
don't talk. Well, because I had my work uniform on, so he was like, so you just getting off of work? And I told him, like, I don't answer questions. And he said, oh, you don't answer questions, huh? I was like, I ain't say anything back. So I can tell his tone changed, and so he just gave me a ticket. But if I answer his question, I was basically, so if I answer his question, it was going to lead to other questions because I think it was out doing a sobriety test. So basically, I just, counseled it like, yo, I don't want to talk to you. Just do what you need to do and get out my face.
Well, you didn't say all that, but
So
you just said, I don't answer questions.
no, yeah, just don't I don't answer questions.
Yeah. And that is sound advice for any of us that when you're approached by a police officer or any law enforcement, one time you say, on advice of counsel, I have nothing to say. I do not answer questions. And they said, well, why don't you answer questions? You keep your mouth shut. So
Yeah, that. Yeah, and also I had the testicular fortitude to ask him a question. I was like, so are you operating under presumption that just because I'm physically in Pennsylvania that your constitution and laws apply to me? And it was like a blank look on his face. And he just stood there froze for like 5 seconds. He was like, the ticket is proof that the constitution and law applies to you. And I was like, so how does the ticket prove that your laws apply to me? And all he responded was, well, I see you in court. I see you in court. And
wow.
he got real frustrated because I kept asking for evidence to support his claim, and he couldn't do it. So he's like, well, you're free to go, and just hurried off.
Roy, it's a great story, and I'm glad it ended that way. It's just, for the most part, that's something that could have gotten you hurt pretty bad.
Yeah.
So I want to just, again, go on record. I think what you did, that's cool, especially you get that deer in the headlight look. I love that. I'd rather have him get that deer in the headlight look in court, where it's less likely he's going to pull a gun or a taser or a baton. So my position is, like I already said, guys, on advice of counsel, I am not answering any questions, and I keep my mouth shut. You cannot answer any of his questions. If you do answer one of the questions, the court can and may probably rule against you that once you answer that question, you waived your right to remain silent. So you got to keep your mouth shut. So, wow, that's great. See, one of the things you could have, and this is just between us. I'm not saying anybody should do this. Cops are extremely dangerous, unstable individuals here.
Yeah, they are.
But if it happens outside of a traffic stop, when someone says something like that to you, that the ticket is evidence that the Constitution applies, there's so many ways to go about this one. You can say, oh, so before you wrote the ticket, there was no jurisdiction? I mean, it's like when they say, well, the driver's license. Well, how I had a client who was an MD, and the IRS thought that they were going, well, this return that you filed 5 years ago, this is our evidence that you're required. Really? So if I never filed before and I never file again, you wouldn't have any evidence. See, it's just like when they turn around and they say that, anything that you've done before. Oh, if I never done it, if I didn't do it. Of course, we could always ask, exactly how does you writing, you writing this ticket, how does that prove the Constitution applies? Explain this one to me. You may get the chance to ask him that question on cross-examination. So you can bring him back to the day in question. Remember, officer, that you said, when I asked you this question, you remember you said to me? Because contrary to what may be said, anything that the police officer said during the stop is going to be open for cross-examination. So hopefully this doesn't go that far. Hopefully that this is
because I want
out that.
Yeah, because like when I send the motion, do I send it to the officer too, or just the court?
Well, I have instructions in this, but I want to cover this. Anytime anybody has any questions, you can always email me. It's radoffmarkstevens.net, and it's markstevens@mail.com. And you can always call the show. Everything is going to be filed with the clerk of the court. everything is going to be filed with the clerk of the court. Whatever we do file with the clerk of the court, you absolutely have to file or mail a copy to the prosecution or opposing counsel. Whatever, here, since it's just, it's a minor traffic, there may not be a prosecutor. So like I say in the instructions, as long as we're doing minor traffic and we know, because we've got no indication in the mail that there's a prosecutor, then we can safely send it to the police officer. He will then pass it off to a prosecutor. And then once the prosecutor is on there, his notice of appearance, and he's filing paperwork on behalf of the government, you can absolutely not communicate with that police officer ever again while there is an active ticket, except for obviously if you see him in court and he's a witness. But other than that, you have no communication with him at all unless he forces it.
Oh, okay.
And again,
All
if he
right, so
forces it,
basically,
you
so
still keep your
if
mouth
I'm in
shut.
court, this last question. So if I'm in court and a judge asks me, did I run the red light? I can actually say that I plead the fifth and don't answer questions, right?
If a judge asks you, if he's asking you a question going to the merits of the case, you got to keep your mouth shut. I would object. I would say,
Okay.
objection. Who's prosecuting this case?
Okay, I just want to, again, because I need some court role play, or they may send a motion, they may send a dismissal through the mail because I live in Virginia and this happened in Pennsylvania, so I don't want to travel back and forth, to Virginia to Pennsylvania.
Okay, make sure if you order the motion to dismiss that you send me a note that you need it for Pennsylvania.
Okay.
And I can get you the crossed over Pennsylvania template. All right. And definitely get some role playing.
Thank you, Mark.
Oh, you're welcome.
So
You're very welcome. Appreciate the call. I am not going to be able to take any more calls. I am out of time. And unlike on the Saturday show, I don't have the luxury of extra time. I know last week I didn't either because I had a rare appointment after the show, but I do have to get all these shows posted. It's on YouTube, so it's there. But for those who do listen to the show on LRN.FM, I am in the podcast loop. So I do need to get that material posted and over there. But you can always get the show right here on my YouTube channel, No Stay Project. I will get stuff posted on the website. I'm sorry for whoever I may have missed. Again, we'll be live Saturday, so I will be able to get to whoever we missed. And I know there was a few, so I do apologize, especially when you are so patient. But we covered a lot of ground here today, and I'd like to be able to, the point of the show is to help people to get to better defend themselves, to more effectively defend themselves, and to limit the damage that these people want to do to them. So I do tend to spend a little bit more time with each caller, and it's great because we're totally commercial free now. So we're able to do that. So I think in general, we still cover more ground because we're not, we don't have the commercial breaks. But if you like the material, you like the show, you like to support the show, it is appreciated. I appreciate everyone's support of the show. You can do so at markstevens.net and markstevens.sales.com. If you disagreed with whatever was on the show today that I spoke about, if I got my facts wrong, if the logic is way off base, please, the easiest way to hash these issues out is to call the show at 218-632-9399. The passcode is 2020. Again, I appreciate everyone tuning in today. We'll be live on Saturday. So till then, salud.